There's a 32-ton cement mixer sitting at a 40 degrees angle on the side of my mountain right now, and it has been there for 11 days. 11 days. The driver is long gone. The HOA's lawyers are making very polite phone calls that I am choosing not to answer. And the smell, the smell of diesel fuel bleeding slowly into my creek is going to be a problem for a lot more people than just me. I warned them in writing twice with photographs, GPS coordinates, and a geotechnical engineer's letter attached. They sent back a cease and desist. So, here we are. My name is Garrett Voss. I own 47 acres on Saddleback Ridge in western Colorado, and I'm about to walk you through exactly how a homeowners association tried to turn my property into their personal highway, and how a stuck cement truck became the beginning of their end. What would you do if a neighborhood committee just decided your land was their road? Drop it in the comments. And while you're at it, where are you watching from? Let me know. And hit like, subscribe if you'd like to help the channel grow. That little thanks button down below means a lot.
Let me back up about 4 years, because none of this makes sense without the backstory. I grew up in Pueblo, the son of a pipe fitter and a woman who drove a school bus for 22 years without ever calling in sick once. We weren't rich, we weren't connected. But my father had one piece of real estate philosophy that he drilled into me from the time I was about 10 years old. Buy land they can't make more of. Near water they can't move. So when I finally had enough saved, after 12 years of commercial HVAC work and 3 side businesses I won't bore you with, I bought Saddleback Ridge. 47 acres, Headwater Creek running through the northeast corner, views that make your chest hurt in the good way. A small cabin that needed a new roof, a new foundation, and basically a new everything, but mine. Clean title, no liens. The Saddleback Estates HOA was there before I arrived. They governed the 140-acre planned community that sat directly to my east, a grid of $250,000 houses with vinyl siding and neighborhood covenants against basketball hoops visible from the street. Fine people mostly. I had no quarrel with them. The road situation, though, that was going to be a problem from day one. The only paved access to Saddleback Estates ran through a low spot that flooded every spring. The county had promised to fix it for about 8 years and hadn't. Developers had been circling the area, and a new subdivision was being planned for the ridge above, which meant construction trucks, cement mixers, delivery vehicles, heavy stuff. The estates board had been lobbying the county for an alternate route for 2 years by the time I showed up. That alternate route happened to be a 2-track dirt path that crossed the lower corner of my property. It had been used, informally, by my predecessor, a retired school teacher named Dwight, who never locked his gate and didn't much care who drove past. Dwight sold to me and moved to Flagstaff. The informal arrangement died with his willingness to allow it. I didn't mind neighborly traffic, ATVs, the occasional pickup, even the county's weed spraying rig. But when I started seeing survey flags along my fence line, bright orange ones, set by someone I hadn't given permission to enter, I got curious. And when I found out the Saddleback HOA board had submitted a formal road improvement proposal to the county that included my lower track as a primary haul road for the new development, I got something a little sharper than curious. The HOA president at that time was a woman named Dolores Fitch. You'll want to remember that name. Dolores was 61, a former real estate broker, and had served as HOA president for going on 6 years. She had a gift for making bureaucratic power grabs sound like community service. She organized the neighborhood watch. She ran the holiday light competition. She also, I would come to learn, had a side arrangement with the developer behind the New Ridge subdivision, a gentleman named Rupert Caswell, that involved a referral fee on any lots sold in the new community. Not illegal. Not exactly above board either. The first time I met Dolores in person, she drove her white Cadillac SUV right through my open gate without knocking, parked next to my barn, and told me she was there to discuss the easement. Not ask, discuss. Like it was already settled and we were just working out the details. The smell of her perfume, something floral and aggressive, drifted across the gravel drive as she stepped out holding a manila folder and a smile that didn't touch her eyes. "Mr. Voss," she said, "the community has really been counting on this access." "Ma'am," I said, "the community doesn't own this land." That was the beginning. It was also, in hindsight, the nicest conversation we'd ever have. Over the next 6 weeks, I started receiving paperwork. Not hostile paperwork, not yet. Polite paperwork. A letter from the HOA's property management company asking me to consider formalizing existing access. a follow-up from a title company asking if I'd be open to an informal easement conversation, a note from the county roads department, which I found particularly interesting, suggesting that a recorded easement over my track might benefit the broader public. The county roads department, writing to me on behalf of a private HOA. That particular piece of mail I set aside in its own folder. I am not a lawyer, but I am someone who reads contracts before I sign them, which puts me ahead of roughly 70% of the population. So I sat down at my kitchen table. Pine surface, still smelled faintly of the linseed oil I'd rubbed into it that spring, and I started Googling. What I found was actually pretty straightforward. In Colorado, to establish a prescriptive easement, basically a legal right-of-way that forms because someone used your land openly and continuously for long enough, you need 18 years of uninterrupted use. My predecessor Dwight had owned the property for 9 years. Before him, a cattle rancher owned it for 11, but there were no records of the track being used commercially during that period, only by the rancher's own vehicles. The HOA's attorneys knew this, which is probably why they were trying to get me to agree to something in writing rather than going to court. I wrote back to the property management company with a single, clear sentence. There is no existing easement over my property, and I am not entertaining the creation of one. I sent it certified mail and kept the green card. 2 weeks later, the survey flags reappeared. This time, they were set inside my fence line, not along it. Someone had entered my property, without permission, and stuck orange plastic flags into the soil of my lower track, at 20-foot intervals. It looked, from a distance, like a construction crew had already been hired. The crunch of the gravel under my boots felt different that morning, purposeful, angry, as I walked the line and counted 15 flags. 15. I pulled every one of them. I photographed them first, of course, with GPS metadata active on my phone, and then I photographed the footprints in the soft earth near my fence post. Boot treads, at least 2 sets, one significantly heavier than the other. I filed a report with the county sheriff's office for trespassing. The deputy who came out was pleasant, took my photos, wrote up a report, and told me these things usually work themselves out. It did not work itself out. What happened next was that Dolores Fitch called the county commissioner's office and described me as an uncooperative out-of-state investor who was holding the community hostage. I had lived there full-time for 2 years at this point. I was from Pueblo. I paid county taxes. But here's where Dolores made her first real mistake. She said this in a recorded public comment session for the county roads budget hearing, a hearing that was, by law, recorded and archived as a public document. She said I was creating an unnecessary burden on the Saddleback community's access to emergency services. Emergency services. She invoked emergency services to try to justify taking an easement over my private land, in a public forum, on the record. I requested the transcript the next day. The beauty of public records requests in Colorado is that they're not very complicated. Under the Colorado Open Records Act, CORA, you can request documents from county agencies and generally receive them within 3 business days. All I did was submit a written request to the county clerk for the audio recording and transcript of that specific public comment session. Cost me nothing. Took about an afternoon. Now I had Dolores, on record, making a statement that wasn't just misleading, it was potentially defamatory. Because she hadn't said, "We need better road access." She had said that I specifically was blocking emergency access, which was false. Provably false, since the main road to Saddleback Estates was perfectly functional, except during the 2 or 3 weeks of peak spring flooding, and the county's own records showed 0 emergency response delays attributable to road conditions in that area. I didn't do anything with the transcript yet. I just filed it. You know that feeling when you're playing cards and you draw something good, and you very deliberately set your expression flat and reach for your coffee? That was me, sitting at that pine table, sliding a transcript into a manila folder and labeling it with a date and a case number I made up for myself. Stack building. That's what my dad would have called it. Spring came around again, and with it came the flooding. The same flooding that was apparently my fault, or at least fault adjacent, in Dolores Fitch's version of events. The low road into Saddleback Estates went underwater for about 17 days. During that time, residents used a gravel bypass that the county had actually installed 2 years prior, specifically for this seasonal situation. It added about 4 minutes to their commute. 4 minutes. This was the emergency. What changed that spring was Rupert Caswell. The developer behind the new Ridge subdivision had apparently secured his financing and was now on a timeline. He needed haul road access up the ridge before summer, which meant he needed my lower track, or something very close to it, opened up and improved to handle fully loaded concrete trucks and heavy equipment. The county road wasn't rated for that weight. The Saddleback access road wasn't either. My track was the most direct route, and if it could be widened and graded, it would save Caswell's crew roughly 3 miles of driving per load. That's money. Real money. 10 loads a day at a lower fuel and time cost adds up fast over a construction season. So, Rupert Caswell showed up at my gate. Unlike Dolores, he actually knocked. Well, he stopped his truck at the cattle guard and honked. I walked down to meet him. He was maybe 55, tan in the way that outdoor money looks, a turquoise bolo tie that probably cost more than my first truck. He had a warm handshake and the eyes of someone calculating while they smiled. "Garrett," he said. "Not Mr. Voss, just Garrett, like we were old friends. I think we can make this work really well for both of us. What if we talked about a temporary construction easement? 6 months, maybe 8. We'd grade your track, put down compacted base, leave it better than we found it." I let him finish. "Rupert," I said, "what weight class are we talking about for your haul vehicles?" He told me. "Fully loaded cement mixers, Class 8 trucks, at roughly 66,000 pounds gross vehicle weight." I nodded. My lower track crosses a seasonal drainage at the 2,000-foot mark. That crossing sits on clay-dominant soil with a seasonally high water table. A geotechnical survey I had done 18 months ago found that the load-bearing capacity at that point is insufficient for heavy commercial traffic without engineered remediation. I have the report. He smiled again, the smile narrowing slightly. "We can address that. Our civil engineer can... Your civil engineer would need to engineer a culvert replacement and soil stabilization on my property, which I would have to approve, and which would require a county drainage permit, which would require my signature as the landowner, and I won't be signing." He drove away still smiling, but the warmth had gone out of it. Within 2 weeks, the HOA sent me a formal notice that they were pursuing a public interest easement through the county, a rarely used mechanism in Colorado law that essentially asks a government body to condemn a private easement for public benefit. I looked it up. The mechanism exists. It's also expensive, slow, and requires the condemning authority, in this case the county, to demonstrate that the easement is genuinely in the public interest and that fair compensation is paid to the landowner. It's not a fast process. It typically takes 12 to 18 months and often fails. More importantly, it requires the county to be a willing participant. Counties don't love condemning easements from private citizens. It's politically messy. I attended the next county commissioner meeting. I didn't speak. I sat in the 3rd row with a notepad and my manila folder, and I watched the commissioners' faces when the HOA's attorney, a smooth young man named Fletcher, who wore a fitted blazer to a county meeting, presented the public interest easement petition. Commissioner Dale Ortega, who'd been on the board for 14 years and had the look of a man who deeply wished he were fishing, asked one question. "Is there a safety hazard the county can document?" Fletcher said there was. Ortega looked at the county roads engineer sitting at the side table. The engineer shook his head almost imperceptibly. Ortega shuffled his papers. "We'll take it under advisement." Under advisement in county government means roughly the same thing as the bottom of a very full filing cabinet. I walked out of that meeting feeling cautiously good, but I also knew that Dolores Fitch and Rupert Caswell hadn't spent this much time and political capital to quit. I was right. They hadn't. Late July. Heat sitting on the ridge like a wool blanket. The grasshoppers were so thick that summer that you could hear them in the scrub oak from 30 yards away. A dry, papery sound, like someone shuffling a deck of cards very fast. That's when the notices started coming from the county building and planning department. 3 of them in 6 weeks. The first alleged that a storage shed I'd built, entirely within setbacks, with a permit I'd pulled 2 years prior, was in potential violation of drainage easement restrictions. The second claimed my cattle guard installation needed county inspection sign-off that, according to my permit paperwork, had already been completed. The third was an inquiry about a reported unpermitted stream crossing modification on my property. I had not modified any stream crossing. I called the county planning office. The clerk I spoke to was apologetic, in the way government workers get when they know something is wrong, but don't want to say it directly. Lots of throat clearing, references to standard review procedures, offers to schedule an inspection. "Can you tell me who filed these complaints?" I asked. She paused. "Complaints are filed anonymously." "Are they really, though?" Another pause. "The department doesn't release that information." I thanked her, hung up, and filed a KORA request for all complaints received by the county planning department regarding my parcel in the previous 12 months. Under Colorado Open Records, complaint records from county agencies are generally public unless there's a specific exemption, and the identity of a complaining party, unless the complaint involves a criminal investigation, is typically not exempt. 6 days later, I had a document with 3 complaints, all filed on the same day, all from the same email domain. The email domain belonged to the Saddleback Estates HOA property management company. So, Dolores Fitch's organization had been filing false regulatory complaints against me with the county, in what appeared to be a coordinated attempt to tie me up in bureaucratic review and make my life expensive. This is called regulatory harassment, and it's not a crime in most jurisdictions, but it's absolutely relevant to civil litigation, particularly if you can show a pattern of behavior intended to coerce a property owner. I put the KORA response in my folder. The folder was getting thick. Here's where I made a decision that I want to explain carefully because it matters. I could have hired a lawyer right then and shot off a demand letter. That would have felt satisfying for about 48 hours. But demand letters tip your hand. They tell the other side exactly what you have and give them time to prepare. What I wanted instead was to build a complete picture. Every incident, every document, every public record, before I made a single move. Not defense, not even offense, setup. Think of it like setting a deadfall trap. You don't spring it early. You wait until the animal is fully committed. Meanwhile, Rupert Caswell had apparently decided that official channels were too slow. Sometime in early August, his crew, without notifying me, without any permit, and certainly without my permission, began clearing brush along my lower fence line to assess conditions, according to the note they left on my gate post. They'd brought a skid steer. I could see the track marks in the dry soil from the ridge. I documented everything. Photographs, measurements, tire track casts made with a bag of plaster of Paris I kept in my barn. The skid steer had gotten within 40 feet of my fence line. Not technically trespassing. The brush they cleared was on the road right-of-way, but close enough to be a message. The message was, "We're coming whether you like it or not." My response was to install a game camera, the kind hunters use, on the fence post closest to the track. Motion activated, cellular, sends photos directly to my phone. And I called my neighbor on the other side, a man named Thaddeus Burke, who owns 60 acres to my west, and had his own complicated history with Saddleback Estates over a fence line dispute 5 years back. Thad was 72, a retired civil engineer, and had the particular focused patience of a man who has learned that the best revenge is documentation. "Thad," I said, "I think I'm going to need a witness at some point." "Already figured," he said. "I've been watching those survey flags." The cellular camera sent me its first photo at 6:14 the following Tuesday morning. 2 men in high-visibility vests, a pickup truck, and behind the truck, just barely visible at the edge of the frame, the nose of a white Cadillac SUV. "Hello, Dolores. I want to stop here and tell you about a document that changed everything. I almost missed it entirely. When I filed my original KORA request for county drainage permits near my parcel, the county sent me a stack of about 60 pages, mostly boring stuff, utility crossing permits, agricultural drainage waivers. I'd skimmed through it in an evening and set it aside. About 3 weeks after the skid steer incident, I was going through that stack again more carefully, and I found it. A recorded plat document from 1987, filed by the original developer of Saddleback Estates, a company called Ridgecrest Properties, that included a drainage and access note on the subdivision's eastern boundary. The note described a 30-foot wide drainage maintenance corridor along the eastern edge of what was now my property. Not an easement for road use, not a haul road corridor. A drainage maintenance corridor. More importantly, the note included a restriction. No permanent structures or roadway improvements shall be constructed within the corridor without written consent of the downstream property owner. And in 1987, when that plat was filed, the downstream property owner was a watershed conservation district. That district had since been dissolved, but its assets, including any consent authority under recorded documents, had transferred to the county itself, meaning the HOA didn't just need my permission to put a road through there. They needed the county's permission too, and the county had never given it. More than that, the county apparently didn't know this restriction existed, because it had never come up in any of the HOA's easement filings or Caswell's development applications. I called Thaddeus. He drove over that evening, sat down with the plat, put on his reading glasses, and read it 3 times. "Garrett," he said slowly, "this means every single permit application Caswell has filed for that ridge development is incomplete. They were required to show compliance with this restriction as part of their drainage impact review. And they didn't. They couldn't have. They probably didn't know it existed." He set the paper down carefully, like it was something fragile. "This doesn't just block the road. This potentially voids the drainage approval on Caswell's entire project." I sat with that for a moment. Rupert Caswell had secured financing. He had a construction crew on standby. He had a timeline. If his drainage approval was defective, if a legally recorded restriction had been missed in the county's review process, his project could be placed on hold pending a corrected review. That process, depending on how the county handled it, could take months or longer. And if the county had approved the project without catching the restriction, then the county had made an administrative error. Counties don't love admitting administrative errors. They love being told about them by private citizens even less. But here's the flip side. Bringing this to the county's attention through proper channels meant it became part of the public record. Caswell couldn't quietly fix it. He couldn't make the restriction disappear. And any road improvement over my land, any version of the Hall Road scheme, would be directly and permanently tangled up in a drainage restriction that nobody had the authority to waive without a formal county process. I copied the 1987 plat. I highlighted the relevant clause in yellow. I had a real estate attorney I knew from Pueblo review it over the phone for about 90 minutes. Her exact words at the end: "Garrett, where did you even find this?" I told her I read things slowly. Here's where I want to be really specific, because this is the part people always ask me about. How did you actually set this up? What did you do, step by step? I'll walk you through it. First, the legal structure. My attorney, her name is Rosalind Pruitt, out of Pueblo, and she's the kind of lawyer who keeps her desk very clean and her arguments very sharp, helped me formalize 3 things. The first was a formal written notice to the county planning department, citing the 1987 plat restriction and requesting confirmation that all recent development applications in the affected drainage corridor had been reviewed for compliance. We sent this certified mail to the county planner, the county attorney's office, and as a courtesy copy to the Board of Commissioners. We also attached a copy to a public comment letter I submitted for the next Planning Commission meeting agenda. Here's the legal takeaway on this one. Under Colorado land use law, when a property owner notifies a county of a potentially defective permit approval, the county has an obligation to investigate. They can't just ignore it. The clock starts ticking on their administrative review. The second thing Rosalind helped me formalize was a cease and desist letter to the HOA and to Rupert Caswell personally, citing the documented trespass incidents, the coordinated regulatory complaints, and the 1987 plat restriction. The letter demanded that all access-related activities on or adjacent to my property cease immediately, and that all pending applications involving my parcel or its adjacent drainage corridor be withdrawn. It also preserved my right to pursue civil action for the documented trespass and for what we characterized as a tortious interference with my property rights. Tortious interference, in plain English, means someone intentionally and improperly interfered with your property or business relationships. Filing false regulatory complaints to coerce a property owner is a textbook example. You can absolutely sue for it. The third piece was the simplest and maybe the most satisfying. I went to the county assessor's office, the physical office, in person, and I recorded a formal notice of my ownership and my objection to any unrecorded easement claim on my parcel. Under Colorado's recording statutes, this puts any subsequent purchaser or lender on constructive notice that there is a dispute. Caswell's construction financing was secured through a regional development lender. That lender had done a title search as part of their due diligence. Now, with my notice of dispute recorded, any subsequent title search would surface my objection. Lenders don't love financing projects with clouded title adjacent to their collateral. Rosalind called that one throwing sand in the gears. I liked that phrase. Now the physical side. Thaddeus and I spent 2 long weekends on this. Thad's civil engineering background was genuinely useful here, not for anything dramatic, just for thinking clearly about load and drainage. My lower track crosses that seasonal drainage at a narrow point, about 8 feet of channel width. The crossing was an old timber and culvert affair that Dwight had maintained casually. The culvert was undersized and partially silted. For a few $1,000s of materials and a couple weekends of labor, I had the crossing properly assessed and then physically documented, with engineering notes from Thad, in a way that made its load limitations unambiguous and on record. Here's what Thad found. The crossing, in its current condition, had a safe load rating of approximately 8,000 pounds. Class 8 trucks, the cement mixers Caswell was planning to use, run at 66,000 pounds gross vehicle weight when loaded. That's 8 times over the safe load. We documented this in a formal inspection note, signed by Thad as a licensed civil engineer, and I filed it with the County Roads Department as a road condition notification on a structure adjacent to the county right-of-way. I also installed a simple wooden gate at my property boundary, the kind with a padlock, not dramatic, just there. Posted it with no trespassing signs at the required spacing under Colorado statute, and I placed a second game camera at the gate. The last thing I did was make some phone calls, quietly, not aggressively. I reached out to 2 reporters, one at the regional newspaper covering the county, one at a local TV station in Grand Junction, and I told them I had a story about a development project, a 1987 plat restriction, and some interesting regulatory complaint filings. I didn't pitch it as a controversy. I pitched it as a local land use question that might be worth following. Both of them were mildly interested. I told them to stay tuned. The trap, as my father would have said, was baited. All I needed was for someone to walk into it. I didn't have to wait long. The call came on a Thursday morning, early October. The air had turned overnight. You could smell the first real cold in it, that dry cedar and frost smell that means the mountains are done with summer. And I was feeding my 2 horses when my phone buzzed with a photo from the gate camera, a flatbed truck, carrying what appeared to be road construction signage and traffic cones. I called Rosalind. She told me to document everything and do nothing else, not yet. Over the next 4 hours, 2 trucks and a pickup parked at the edge of my property on the county right-of-way, and 3 men in vests spent the morning placing road improvement survey stakes along the edge of my lower track, not on my land, carefully on the county right-of-way line. Caswell's crew was experienced. They knew not to cross my fence. But here's what they did. They left a set of construction plans, in a bright orange waterproof tube, hanging on my gate. The plans were for a road improvement project. They showed my lower track, on my property, labeled as existing private track, proposed haul route, graded, widened, and fitted with a new culvert crossing. Plans for work on my private property, left on my gate, without a permit, without my consent, without any legal authority. I photographed the tube, the plans, the survey stakes, and the truck's license plates. Then I called the county code enforcement office and reported an unauthorized pre-construction activity adjacent to private property. I also called Rosalind again, and she filed an emergency motion for a temporary restraining order, a TRO, in County District Court, seeking to prevent any construction activity on my parcel or within the documented drainage corridor pending resolution of the 1987 plat restriction issue. The TRO was granted within 48 hours. Judges respond pretty quickly when you show up with a recorded plat restriction, documented trespass history, and construction plans for work on private property that no one has approved. Caswell's attorney called Rosalind the day after the TRO was granted. According to Rosalind, the conversation was tense. Caswell's side was arguing that the plans were exploratory and that the survey stakes were within the public right-of-way. Rosalind pointed out that the construction drawings explicitly labeled my private track as their intended haul route, and that this constituted intent to trespass. The call ended without resolution. 2 days later, I got a different kind of contact. A man named Broderick Vane left a voicemail on my personal cell number, a number I hadn't given to anyone connected with Caswell or the HOA. He identified himself as a community liaison for Ridgecrest Development, Caswell's parent company. He said he wanted to have an off-the-record conversation about creative solutions and mentioned a figure, not a price, just a number floating in context, of $40,000. I did not call Broderick Vane back. I did, however, play that voicemail for Rosalind, who had me forward it to her and then told me, very calmly, that under Colorado law, an unsolicited offer of money in connection with ongoing litigation and regulatory proceedings has some interesting implications. We kept it. Meanwhile, Dolores Fitch had apparently decided to escalate on the community front. She sent a letter, a physical letter mailed to my address, that referred to me as the out-of-area speculator blocking Saddleback's growth, in a message that was supposedly addressed to HOA residents, but somehow arrived at my mailbox. The letter claimed that my refusal to cooperate with community needs was raising concerns about property values, and invited residents to a community meeting where the road issue would be discussed. I was not invited to the meeting, but I found out about it through Thad, whose cousin lived in Saddleback Estates, and sent him the letter. And I found out, through Thad's cousin, that Dolores had arranged for Rupert Caswell to present the road project at the meeting, including a timeline and budget, before any permit had been approved, before the TRO had been resolved, and before the county had responded to my notice about the 1987 plat restriction. She was trying to manufacture community pressure, trying to create the narrative that the neighborhood was behind this, that the only problem was me, that I was the villain standing between Saddleback Estates and its future. I started making plans to attend a different meeting, a much more public one. The cement mixer showed up on a Tuesday in mid-October. I want to be very precise about the sequence of events, because this is the part that people find hard to believe. But I have photographs, timestamps, and a county incident report. The morning started with a call from my gate camera, a convoy, 2 pickup trucks, a water tanker, and 1 Schwing 32-ton transit mixer with Caswell's contractor's name stenciled on the drum. They pulled onto the county right-of-way at my fence line at 7:22 in the morning. By 7:31, one of the pickup trucks had my padlocked gate open. I watched this on my phone from my kitchen. I called 911. Then I called Rosalind. Here's where my physical preparation paid off. Remember the documentation Thad and I had done on the crossing, the inspection note, the load ratings, the civil engineering sign-off. And remember how I'd filed that with the county as a formal road condition notification? There was one more thing I'd done that I haven't mentioned yet. I had the crossing physically marked. Not modified, not altered, marked. Steel stakes driven at the channel edges with fluorescent orange paint and a weather-resistant sign, professionally printed, that read, "Load limit 8,000 pounds, CE inspection on file, county notification ref, file number." The sign was mounted on a T-post driven into my land, 6 inches inside my fence. It was, legally, notice. Clear, documented, visible notice of a load restriction on my private property crossing, backed by a licensed engineer's inspection. When the transit mixer driver cleared my gate and came down the track, and the soil and gravel made that deep-throated grinding sound that you only hear with very heavy equipment, he apparently either didn't see the sign or decided to ignore it. He made it to the crossing. He was about 15 feet onto the creek crossing structure when the old culvert, undersized, partially silted, rated for 8,000 pounds and receiving a load of 66,000, let go on the upstream side. The embankment on my side of the creek channel, saturated from recent rain, gave way under the rear axle. Not catastrophically. The truck didn't tip, nobody was hurt. I want to be absolutely clear about that. But the rear drive axles went down into the embankment bank at about a 30-degree angle. The front of the mixer lifted slightly, and 32 tons of truck were now in a position from which they were not going anywhere under their own power. I had been walking down the track from the moment I called 911. I reached the crossing about 4 minutes after the truck settled. The driver was out of the cab, standing on solid ground, looking at his truck with the particular stillness of a man calculating his next phone call. The smell of diesel was thick and immediate, a dark petroleum smell that settled into the back of your throat. I said, "Are you okay?" He nodded. "Did you see the load limit sign?" A pause. The gate was unlocked. The gate was locked. Someone cut my padlock. I have it on camera. That was the end of that conversation. The county sheriff arrived about 12 minutes later. The county roads engineer arrived 20 minutes after that, because I had called him directly. His number was in my phone from the formal notifications I'd filed. He looked at the sign on my T-post. He looked at the truck. He took photographs. Then Dolores Fitch arrived in her white Cadillac. She parked on the county right-of-way and walked down to the crossing in heels, impractical footwear choice for a mountain creek crossing situation, and stood looking at the truck with an expression that was trying very hard to be composed and not quite making it. "This is your fault," she said to me. "My sign says 8,000 pounds, I said. "How much does that truck weigh?" She didn't answer. What happened next was that Rosalind arrived, and behind Rosalind, having made the drive from Grand Junction, was the reporter I'd called 2 weeks ago, camera operator in tow. Rupert Caswell showed up about an hour later. He stood on the ridge above the crossing, looking down at his contractor's truck, and the look on his face was the look of a man adding up very large numbers and not liking the total. The truck sat at that angle for 11 days. Recovery required a specialized heavy lift crane brought in from Denver. The cost of that recovery, the damaged culvert, and the embankment repair fell entirely on the contractor because they had no permission, no permit, and had ignored posted load restrictions. Their insurance carrier would later dispute coverage on the basis that the operator had proceeded past a visible warning sign. That conversation, the one between the contractor and their insurer, is not my problem. But it is deeply satisfying to know it's happening. Here's what most people don't realize. The truck getting stuck wasn't the ending. It was the opening act. The county commissioners' meeting 2 weeks later was a standing room situation. I'd never seen more than about 20 people at one of those meetings. That evening, there were north of 100, which for a rural Colorado County meeting is essentially a riot. People sat in folding chairs that spilled into the hallway. The local TV station from Grand Junction had a camera set up in the corner. The reporter I'd called, a woman named Carla Whitfield, who'd been covering land use in that region for 8 years, was in the second row with a notepad. I had a 3-ring binder, color-coded tabs. I am not being dramatic when I say that binder was the most organized document of my life. The agenda item was a combined hearing, the county planning department's response to my 1987 plat notification, and an inquiry into the processing of Caswell's development permits. The county attorney had asked both parties to present. Rosalind went first. She walked through the 1987 plat restriction in about 12 minutes. Methodical, clear, a courtroom voice calibrated for a room full of people who weren't lawyers. She showed the highlighted clause on a projected image. She showed the county's own drainage approval for Caswell's project, and then showed that the approval had never referenced the recorded restriction. She explained, in one sentence, what this meant. The drainage approval was procedurally defective and would need to be reissued through a corrected process. The county attorney, sitting at the side table with the expression of a man who had not slept well, confirmed this was accurate. Caswell's attorney tried to argue that the restriction was unenforceable due to the dissolution of the original conservation district. The county attorney, very quietly, explained that dissolved districts transfer their interests to successor entities, in this case, the county itself, and that the county's own interests were therefore implicated. The county could not, in other words, approve a project that violated a restriction it now held authority over. Caswell's attorney sat down. Then Rosalind laid out the trespass documentation, the game camera photos, including the one with the white Cadillac visible at the edge of frame, the coordinated regulatory complaints filed from the HOA's property management email domain, the voicemail from Broderick Vane and his floating $40,000 number, the construction plans left on my gate for work on my private property. All of it. Every item dated, sourced, and organized. The room got very quiet. Commissioner Ortega asked the HOA's attorney, a different one from Fletcher, this was a more senior partner, whether the HOA had authorized the filing of planning complaints against my parcel. The attorney said he'd need to consult with his client. Ortega said, "Your client is in this room." Dolores Fitch was, in fact, sitting 4 rows back. She had dressed carefully for this, silk blouse, reading glasses on a chain. She did not stand up. The The commissioner looked at her for a long moment. Then he looked at the camera in the corner. Then he looked back at his papers. The county will conduct an administrative review of all permit applications associated with the Ridge Development Project, he said. All pending construction activity in the associated drainage corridor is suspended pending that review. We'll also be referring the regulatory complaint matter to the county attorney's office for a determination of whether any county resources were misused. He paused. Mr. Boss, on behalf of the board, I apologize that you had to go through this process. That was it. No gavel banging, no dramatic speech, just a public official, on camera, apologizing to a private citizen on the record. I said, "Thank you, Commissioner." Dolores left before the meeting concluded. I watched her go, the measured pace of someone trying not to look like they were leaving quickly, heels clicking on the tile, and I felt something I hadn't expected to feel. Not triumph exactly. Something quieter, something more like relief. Rupert Caswell sat in his seat for about 5 minutes after the meeting ended, not moving, staring at the table. His financing, I would later learn, had a covenant requiring uninterrupted permit status. With the drainage approval suspended, that covenant was in technical default. His lender froze disbursements the following week. Carla Whitfield's story ran the following Sunday. It was thorough. It named names. Dolores Fitch resigned from the HOA board the following month. Broderick Vane, the community liaison, quietly left Caswell's organization. And the truck? Recovery cost the contractor just over $18,000. The embankment repair, for which I submitted a damage claim, cost $4,000. I received a check. Here's where we are now, roughly 14 months out from the meeting. The 1987 plat restriction has been formally acknowledged by the county and incorporated into the development review standards for that drainage corridor. Caswell's Ridge project was eventually permitted, a scaled-down version with a legitimate access road that goes nowhere near my property, after a corrected drainage impact review that took 7 months. He lost one full construction season. He also lost his original financing arrangement and had to refinance at a less favorable rate. The HOA has a new president, a guy named Marcus who installs solar panels for a living and mostly just wants the newsletter to go out on time. He reached out to me personally about 4 months after the meeting, introduced himself, and asked if we could start over. I told him I had no problem with that. He asked if there was anything he could do. I told him there was one thing. Thaddeus Burke and I had been talking, over that whole long year of conflict, about the Headwater Creek on my property. It's a small stream, not much to look at in August, but critical spring habitat for 2 species of native cutthroat trout. The drainage pressure from new development on the ridge was a real concern for that creek, and the 1987 restriction, while useful for my purposes, didn't provide comprehensive long-term protection. I had been in conversation with a Colorado land trust about placing a conservation easement on the riparian corridor of my property, about 12 acres along the creek, that would permanently restrict commercial development, road construction, and heavy ground disturbance in that zone. A conservation easement, once recorded, runs with the land forever. Doesn't matter who owns the property in 50 years. The creek stays protected. The land trust was willing. The process takes time and money, mostly attorney time and appraisal costs. Total tab was about $9,000. I asked Marcus whether the HOA, as a gesture of community repair, might consider contributing to that cost. He called me back in 3 days. The HOA board had voted. They would contribute $4,000 toward the conservation easement. In the interest of long-term watershed health for the whole area, the formal letter said. Which is true. The creek drains partly through the low area behind Saddleback Estates. If it floods dirty, they feel it too. The conservation easement was recorded 6 weeks ago. The 12 acres along that creek are now permanently protected. There will be no haul roads, no culvert modifications for heavy equipment, no commercial disturbance of any kind in that riparian corridor. Ever. I stood at the creek the morning after we got the recording confirmation. It was about 7 in the morning, cold enough that I could see my breath, and the water was low and very clear over the pale gravel. There's a pool about 40 yards up from the fence line where the big cutthroats hold in the summer, where the water deepens under a cut bank overhang and goes that particular dark green that means cold and deep. I stood there for a while and just listened. water over rocks, a dipper bird working the shallow edge, wind in the ponderosas up the slope. My neighbor Thad is funding a small scholarship, $500 per year, through the County Agricultural Extension Program, for rural students pursuing studies in land use, water rights, or environmental science. I matched it. It's not a lot, but it's something, and it's ongoing. The track where the cement mixer got stuck is still there. I haven't repaired the crossing. I've planted native willow cuttings along the bank. In a few years, the root systems will stabilize that embankment better than any culvert ever could. People ask me sometimes what the lesson is. I think the lesson is what my father taught me, which is, buy land they can't make more of, near water they can't move. But also, and this part took me a few years of dealing with HOA boards and developer pressure and county bureaucracy to really understand. The land doesn't defend itself. You have to know it, document it,